Welcome to California in Focus. I'm Eliana Kernodle, standing in for David Mastio today. After Governor Gavin Newsom signed a bill banning parental notification for gender change requests at K-12 schools, Elon Musk announced he is moving SpaceX and X out of the state. Joining me to tell us more is Kenneth Schrupp, California reporter for the Center Square. Kenneth, what is motivating Musk here?
For Musk, it seems that this is based on both the business climate and a lot of the cultural laws that California is passing. Cal Matters reporter Alexei Koseff noted that this comes out about 2 years after Musk's transgender daughter cut ties with him after attending a school in Los Angeles, and 17 months after Newsom appeared with Musk to announce the opening of a Tesla engineering headquarters in Silicon Valley, during which point they probably had some kind of conversation. Elon Musk, in his post on X announcing the move, said, "This is the final straw. Because of this law and many others that preceded it, attacking both families and companies, SpaceX will now move its HQ from Hawthorne, California to Starbase, Texas. I did make it clear to Newsom about a year ago that laws of this nature would force families and companies to leave California to protect their children." About 20 minutes after that tweet, Musk announced he's also moving the headquarters of X to Texas as well.
Can you tell us more about this bill that Newsom signed that initiated this response?
Yes, AB 1955 is a bill that bans school districts from adopting policies that require parents to be notified if a child wishes to go by a different name, use facilities or programs that are sex segregated but of a different gender, for example, use another restroom or play on a different team. This was presented as a bill that would stop forced outings. About a year ago, California's Department of Education adopted guidance on its website and an FAQ telling schools that they should not disclose children's gender-related record change requests to parents. After the California Department of Education issued this, school districts passed rules requiring schools notified if their children request to change their pronouns, go by a substantially different name, or use those gendered facilities and programs for children of the opposite gender. California Attorney General Rob Bonta supported lawsuits against these school districts, the first of which to adopt this policy was Chino Valley Unified School District. So Chino Valley's policy required parents to be notified within 3 days if a student is involved in violence, talks about suicide, or requests to identify with or participate in programs or use school facilities that are for gender different from what is on their birth certificate or official records. So there was a lawsuit in the state court level in which the state court issued a preliminary injunction against some parts of the policy, but allowed other parts of the policy to go forward. A preliminary injunction just means that a policy or a law is going to be on hold until a full trial can be held. So the preliminary injunction ruled that the clauses on notifications for requests to be treated as the other gender or use sex-segregated programs, that would be on hold until a full trial could be held. But that its policy requiring notification to parents for if a child wants to change their official or unofficial records, that could keep moving forward. So Chino, they updated their policy in March to reflect the preliminary injunction. That ends up leaving this case in limbo because there's nothing for the state to really sue against. Because if the judge decides that this one part of the policy doesn't need an injunction because it doesn't seem like the state is going to win on that, it doesn't make any sense for this lawsuit to really continue, because it does seem like the state courts would uphold the part of the policy that is still continuing and was amended to include just that.
And so now the governor has signed this bill that sort of puts into law what had already been part of the practice of the education department. And now that it's been put into law, the same school district, Chino District, is bringing a lawsuit against them. Can you tell us more about it?
Yes. Chino Valley and parents of California public school students have filed a lawsuit, again, with the Liberty Justice Center, who's been representing Chino in this, but in federal court instead of state court. They are claiming that this ban is unconstitutional under the Due Process Clause of the 14th Amendment, saying the state is depriving parents of their right to make decisions about the care, custody, and control of their children. They're also making a First Amendment claim that religious parents' beliefs are violated by the ban, and a third claim that this is in violation of the Family Educational Rights and Privacy Act, which requires schools that receive federal funds to guarantee parent access to student education records. Now, this bill didn't have an urgency clause, so it does not take effect until January 1st, which means that it might take some months before a federal district court looks at and reviews this case. But it's important to see that this is in federal court, not state court, because, first of all, it can affect a much larger geographic area than just California. And also, if the Chino Valley School District does not win, there are several levels of appeal. They can appeal to the Ninth Circuit Court. And if that doesn't go in their favor, they can appeal to the Supreme Court.
Well, I'm sure we will continue to follow this story as it goes forward, both in this lawsuit and also in seeing the impacts of a couple big businesses leaving California. Thank you for your insights on these stories, Kenneth. Listeners can keep up with these stories and more at thecentersquare.com.